Hi, I'm Vicky Follins from Deloitte, and I'm here with Christina Rosette from Covington and Burling and Sarah Deutsch from Verizon. And we're here to talk about the new gTLD program as well as the Trademark Clearinghouse and what trademark holders should be looking into in this new upcoming gTLD space. Hi Christina, a question for you. I was wondering if you saw that more people were talking about the Clearinghouse and showing interest of putting trademarks in the Trademark Clearinghouse.
Absolutely. I think it took a while for brand owners outside of those who've been following the process closely or actually applied to understand that gTLDs are in fact launching, that the sunrise periods are starting, and that the pace is really picking up significantly. I think we've seen about 180 are either launched or are in progress now. And as that pace increases, I am getting a lot more inquiries as a TMCH agent about what marks do I need to put in, how do I put them in, what happens after I put them in. So absolutely.
And how do you assist your clients with the strategies around what marks to put in the Clearinghouse?
There's a broad strategy that I've used, but the specifics obviously vary depending upon the client and depending upon their business and their trademark portfolio. What I advise clients to do is really start with the list of TLDs and identify the ones that are of interest to them, whether because they anticipate that they will want to have a domain name registration in that TLD and actually have an active presence, or because there's something about the TLD that suggests that it might be more likely to be a space where there's going to be a lot of online abuse. And once they've done that, then work from what are their most important marks, what are the marks that they really need to ensure are taken care of and that they can participate in the sunrise. Because the costs for the clearinghouse are not high at an absolute level, but once you start multiplying that registration by registration, it can add up pretty quickly. I've also encouraged clients to pay particular attention to their non-Latin script marks, their marks in whether it's in Cyrillic or Arabic or katakana, just to ensure that as those TLDs go live, that they really are in a position to participate.
And do you think that those IDN TLDs will attract more attention for the new space for brand owners to commercialize and put their products in that space?
I think eventually, I think the uptake is probably going to be slower than for a Latin character IDN, but a Latin character TLD, but I would expect that if you look at certain TLDs 1 year out from launch, that we probably will see more registrations and more active sites in the IDNs.
And do you find that as well, Sarah? Do you see for Verizon also a potential use in the new IDN TLDs, or does...
We don't really see, I mean, we see other people having probably more use in the new IDNs than for, a US brand, but we're monitoring that space carefully, and we're a bit concerned because we don't see any monitoring and watching services in the new IDN, so it's hard to know if somebody's already taken your domain name and put it in a different character set, but that is something we're very interested in. And I was wondering, from your point of view for the Trademark Clearinghouse, are you seeing people who think that the Clearinghouse is something that it's not? Are they getting confused about what it actually does and doesn't do?
Definitely, especially when we're trademark holders coming directly. So it is a global database, so we get clients from all over the world. And some of them get confused by the fact that they think that they're actually registering a trademark with the Clearinghouse, and it's actually recording your registered trademark with the Clearinghouse. It's confusing for some trademark holders, and they think that we're just registering a trademark while we're verifying it. And secondly, they actually think by putting their trademark in the Clearinghouse that they are being protected in all the different TLDs. So they don't realize that they have to go ahead and go do another step and actually register their domain name as well. So they think it's a full stop service and that they're protected in all the TLDs.
One question that I had that I've gotten a lot, particularly as the pace of new gTLD launches increases, what are you seeing in terms of the validation time between the date that a trademark owner or a trademark agent puts the data in and when they can rely on it because it's gone through the validation process? What's that current time?
So it all depends if all the information is correct or not, because we have an incorrect process. So if information is wrongly submitted, they can correct it. So that takes a little bit longer because because of course the client has to go back and look at what's mistakes and then fix it, and then it goes back to NRQ. But when an application is fully correctly applied for, then it takes about 2 or 3 days at this moment. And some even when we know that there are some certain TLDs that a lot of people have interest, we actually get more people to work on the project. And we try to, even sometimes in 24 hours, we try to verify the trademark record.
Excellent. That's
And
good to know.
are both of you seeing any instances where people are gaming the Trademark Clearinghouse, so they're putting in trademarks that don't really belong there, or getting an improper registration and then registering it in the Trademark Clearinghouse?
One difficulty that I have had is explaining to both clients and non-clients that there are many marks that are perfectly valid, that are dictionary words. And in fact, if they've been used for a significant period of time, they're actually going to be very well known. So the fact that it's a dictionary word should not automatically mean that it's not entitled to the same protection. But I have heard reports of that. How about you?
Yeah, I have read as well that there were at least one instance where someone applied for trademark registration in another country based on generic words that were just stamped on a ballpoint pen, and then used those registrations to get into the clearinghouse. So I'm curious, what would be the process if there was, something like that would occur for a trademark owner to contact the clearinghouse, or is that outside your jurisdiction?
Anybody can file a dispute with the Trademark Clearinghouse if they feel that it's incorrectly processed. But of course, we don't provide any legal advice or legal opinion, so we verify that it's indeed a registered trademark, that all the information is correct, that the declaration is provided, and that the sample fulfills on the requirements. And the samples, there are 4 kind of categories of samples, and the mark needs to be included in the sample. What we do an extra check when dictionary words to see that the sample corresponds with the description of goods and services that the trademark is registered in. So we do an extra check there. But we can't provide a legal opinion, so that's up to the lawyers, to the courts to decide. So if somebody comes and says we have a court decision that this trademark has been cancelled, then we of course will immediately take action and invalidate the trademark record.
Sarah, what's your experience as Chief Trademark Counsel for a very well-known brand? What's your experience been with the new gTLDs? Are you seeing more cyber squatting? Are you seeing more abuse?
Yes, we are. We're seeing, I guess, a steady flow of cyber squatting. I'm a bit concerned we're only seeing some and not all, just because the watching services probably have not kept up with, all the cyber squatting that's going on. But we get weekly reports, and what we're seeing probably is more direct cyber squatting of our exact brand right now, because there's so many of these new gTLDs that the cyber squatters can afford to be more discriminating. They'll take our exact name or name of one of our companies in each new gTLD as it launches. And we feel that the cyber squatting really isn't happening in a vacuum, but it's also happening with the assistance of the new registries and some registrars, and the way that they're marketing these new gTLDs is actually encouraging cyber squatters. It's spinning out variations for them. It's telling them these names are available and suggesting new names, and that's making the problem even worse.
And do you see that registries are providing pre-registration orders?
Yes, we feel there are a number of, I guess I would best call them schemes, where rather than just saying here is your sunrise fee, trademark owner, and you can register now, they're creating kind of artificial demand by saying there's a pre-registration period, there's priority pre-registration, and at each artificial period, the price gets jacked up, and so trademark owners are being forced, or that the argument is they're being forced to register preemptively and defensively. And the entire purpose of the new gTLD rollout was to promote innovation, ostensibly. So you should not be encouraging trademark owners to try to register defensively in these pre-registration periods. But that's where a lot of the cyber squatting, we believe, is coming from.
And how are you tracking that? And the reason I asked that is that I know that ICANN has hardwired into the program that there will be certain reviews, both of the gTLD program overall and both of the effectiveness of the RPMs. And I think when that happens, it's my view that it's going to be really important for trademark owners who've had issues, who've seen cyber squatting, to actually have data where they can say, in this many gTLDs, these are how many instances of cyber squatting. These are all the instances in which our mark was put on the priority name list. And we think that these are loopholes that you need to address. So how are you tracking that?
Well, we're both tracking it internally, but we're also working with other INTA members and the Internet Committee in particular, and we're encouraging all INTA members to keep this kind of data, so track the numbers of cases of cyber squatting, the different variations that you're seeing. One other variation is that trademark owners are also finding that sometimes they want to register in their name, but a registry has put it on reserve for themselves or called it a premium name. Mm-hmm. And then when you complain, you get it back. But there's many different flavors of problems, and we're really going to need to collect data, especially not only on cyber squatting, but on the remedies. Are people using the URS, for example? Apparently it isn't being very widely used, which is very, I think, indicative that perhaps the remedy is not what trademark owners would like right now. But we need to track this data, and we need to bring it back to ICANN and show them what's working and what's not working.
So you're talking about tracking the reports and looking at what's going on with cyber squatting. You guys are indeed tracking it. Do you file, or when you are planning to file a complaint, do you file a complaint directly to the registries? Do you go to ICANN? Is there special instances where people can go to when they have complaints with registries, registrars?
Well, there's several paths. One is to write directly to the registry or registrar and send them a cease and desist letter, or sometimes they have a phone number you can call and tell them that things are happening and you can get a remedy immediately. But you can also go to ICANN as well and file something with the compliance office and complain when a registry or registrar appears to be out of compliance with ICANN obligations. What's your experience, Christina?
Very similar. I have found that a number of the registries and registrars have actually been fairly cooperative once the issue has been flagged for them, not all of them, and it sometimes takes a number of communications. ICANN Compliance, I know, has set up on the ICANN.org website under compliance. They have a whole page with links where you can file various complaints, whether it's the Sunrise process is not being complied with, the trademark claims process is not being complied with. The whois data is false. So I do think it's important that trademark owners, when they identify these specific problems, that they use those mechanisms. Because again, I think it will be really important when the time comes for trademark owners to have data, to actually be able to say, here are the number of whois complaints we filed, here are the number of Sunrise complaints we filed. And
do you believe that the TMCH plays already an important role with notifying the trademark holders about what's going on and what the domain name applicants are doing?
Well, I think it's important for trademark owners to realize that the TMCH is a database. So it's helpful. It provides a notice. In my view, the notice isn't strong enough. It's not really a warning. It's very neutral the way it's worded. You may or may not be, impinging on a trademark owner's rights, but it does at least have them acknowledge that they've read the notice, and it is helpful. But people have to realize that it has its limitations. It's really not a pure remedy, but if it serves a deterrent, that's great. But the problem is, if people are incented to register bulk variations of your trademarks on the front end, having a notice on the back end is okay, but it would be better to have a warning on the front end and a warning on the back end.
Right, I agree. I will say that one issue that I didn't anticipate, frankly, was the volume of the trademark claims notices that I'm receiving as an agent. And so I think it is important that entities that are going to become agents or brand owners that are going to register directly, that you decide ahead of time, what are you going to do with all of these? How are you going to investigate them? What's your kind of action threat matrix going to be? Because if you're receiving 50, 60, 70 of them a week, you could end up in a situation where your trademark paralegal is spending all of his or her time just on these notices, and that's not really efficient. So the Trademark Clearinghouse, I think, is definitely doing what it was supposed to do. The problem is that I think the volume is much higher than I personally anticipated.
And then people also need to realize that the Trademark Claims Service will only work for exact variations of your trademark. At some point, people are going to be registering variations and typos, and you're never going to get notices about that. And also, some registries have chosen to have the notice continue indefinitely, but many, they will end after a certain point. And so then you'll be left without that notice, which is really a shame.
And that's why we, as Trademark Clearinghouse, put the ongoing notifications in place, so that as long as the trademark record is in the clearinghouse, you will always receive a notification when somebody registers a domain name that matches the trademark in the clearinghouse. Of course, it doesn't have the acknowledgement of the domain name applicant, so it's only one-folded instead of two-folded. But at least it's an indefinite notice that as a trademark holder, you're
Now, is that
on.
automatic, or as a trademark agent, do I need to opt in for that?
Everybody needs to opt in. So it's a quick yes opt-in for this service. It's included in the service fee, so there's no extra charge. And it's for all your marks, so you don't have to go per label or per mark. It's for all your portfolio, so it's an easy opt-in.
That'll make it a lot easier.
And are you also going to be tracking to what extent, for now, for example, because cyber squatters appear to be registering exact variations, the notice is doing exactly what it needs to do, but at some point are you going to be tracking whether people are registering variations?
We hope so. We are looking into the possibility. Of course, we have to see what the possibility is under our contract, because the Trademark Clearinghouse has been supervised by ICANN, so it's not something that we can autonomously decide. But we are seeing if it's possible to check those variations as well and get the notifications for the trademark holders.
So in addition to the ongoing claims notifications, is there anything else new that's going to be coming out of the Trademark Clearinghouse, or anything else that we should have on our radar screens?
Well, at this moment, the ongoing notifications is the most important one. We also had some issues with trademarks consisting out of mixed scripts. So a trademark, for example, in Japan consists out of the English or the Latin characters and the katakana characters. And they weren't able to submit their trademark in the clearinghouse because the domain names could not be generated. Because apparently these domain names were not accepted by the registries, but certain registries, especially apparently in Japan, they are used to this because this is common use for seeing domain names in mixed script. So we are changing that to make it possible that these trademark holders also can have their trademarks in the clearinghouse. So we hope that that's a big advantage for those markets as well, because it is a global database and we want to try to meet the needs of the global public as well, the global trademark holder. So
Excellent. That's great.
thank you, Christina, and thank you, Sarah, for joining this session. It was very useful. I got a lot of insights again about what the Trademark Clearinghouse can do and what we need to look forward to helping out the trademark holders in protecting their brands on the online space.
Thanks for having us.
Thanks, Vicki.